Well, welcome to everybody again for another session of Mingle Mastermind. Last month we had such a great in-depth conversation about the weapons you need to protect your brand on the legal side. We couldn't get to all of the topics, so we moved it over to this week to have a continuation. And so Sharon's going to be sharing with us lots of things that we need to know about, the key contracts every business needs, service agreements, release of liability and waiver forms. We're going to hopefully get to talking about the difference between independent contractor and employment agreements, and also what you should consider before entering partnerships and joint ventures. So we would love for you guys to really think about what your needs are as you're listening, and questions that you have about how to set your business up properly and safely. And so just put those in the comments and or in the chat, and we will ask Sharon those questions. So welcome to the panel. Just officially, if we have any new people, I'm Melissa, Fashion Mingle co-founder, and welcome if you're new. We have our Sharon Movahed is our featured speaker today. Hi, Sharon. How are you doing?
Hi, Melissa. Hi, ladies. Hi, everyone. So great to be here today. And I'm so excited to get going on this. I know last month, as you mentioned, we had so much to talk about. And afterwards, my inbox was buzzing. And so hopefully we'll get to a lot of the questions. But if, as Melissa said, if you have any legal questions or issues with your business, send it to us in our chat, or even if you remember something afterwards, you can DM me. I'll send you my DM, or email me. And if we don't get to it, we'll do a Q&A at another time so we can all get the benefit of your question.
Awesome. And we've also got Dee from DCG Group. Hi, Dee. How are you?
Hey, Melissa. How are you?
Good. Your volume's a little low.
Let me figure it out.
Scream at us.
Okay. I'll figure it out.
Okay, great. And then Kat's having Wi-Fi trouble. She moved to a new house, and so I think she's having a little bit of trouble. But let's go ahead and get started, Sharon. So you've worked with Fashion Mingle for many years on helping us get our contracts in order. I am a little bit, I think, more of a I do actually read contracts and word for word, but I think most people probably don't. And I do pay attention to every little tiny word. And I think that's because I actually used to work, one of my first careers was in government. And so I had to read legislation a lot. So I understood how one little word can change the meaning of a law. And that's very much the same way contracts are, right?
Absolutely, Melissa. Yes. I mean, it's great that you had that background training, because not a lot of people do. And it can be overwhelming because people get really excited about, working together or creating something. And, the discussions that you have with the person that you're working with or wanting to work with, you have to make sure that whatever it is that gets memorialized in a contract really speaks to that. And it absolutely helps to have someone drafted that knows how to speak that language, because it may be even inadvertently that you may leave out a word, and that can really change the contract dramatically. Mm-hmm. So basically, just to sort of, give you a 101, a contract is really just an agreement between two or more parties, and it creates mutual legal obligations. Now, a work agreement, on the other hand, is a form of a contract. So there's different forms of contracts, and depending on what type of business that you have or what type of agreement that you're getting into, there's going to be various nuances with those types of contracts. A little later on, we'll talk about an employment agreement versus an independent contractor agreement. But just to appreciate, there are key terms that you have to sort of spell out with the other party, and it's going to help govern your relationship. And all of these contracts should have these key agreements, and, including things as simple as, the name of the parties. But I can tell you that can trip some people up, because if you, for instance, are working, say you have a business and you've created an entity for your business as a S corporation or an LLC, right? But you're the actual person that's working under that contract. If you accidentally put your name as the party as opposed to your business as the party, well, now you just opened yourself up to personal responsibility and liability if something goes wrong. And I've seen that happen.
And I have never thought of that. I am so glad you brought that up. I have never thought of it like that.
Yeah, absolutely. And it happens a lot especially with consultants, or, say for a photographer, for example, right? A photographer has a business that he or she is working under, but in this agreement with a brand, let's just call it a collaboration agreement. Well, the brand is hiring the photographer, and they don't know too much details about the photographer's business. So they name the photographer directly in the contract. And luckily I've had the chance to review it. And obviously that's the first issue that I have is, wait a minute, this is not your business. This is you personally. Now you've got exposure to all sorts of risk and liability. So that's really important, just as something as simple as a name, to make sure you've got it right, especially if you're operating under your business as opposed to you personally.
That's a great point.
And then, of course, the services that you're going to perform. What are they? Get as detailed as possible. I mean, this is really where the parties need to sit down and understand what they're going to be providing for each other. So the more specific, the easier it is to resolve conflict when something happens later on. And I'm sure all these ladies can tell you a story about things happening, because it later on does, story. Right? And that's the point, is do it right the first time, get it out of the way. Of course, as we work and develop more experience and go through some things, and you get to be a little bit more savvy with the things and how specific you want to spell out your services and, the things that you're willing to do. But it also helps if you have someone that knows, like someone that's in the industry that can also tell you the things that can go wrong. So you do recognize to be more specific. And the compensation, of course, again, I can't tell you how many times I've seen where it's, there's hourly, there's flat rates, there's contingency, right? So if you get something done and you win something, or, then you'll get paid. But what if you perform services? Do you not get certain things as well? And what about your expenses? If those things don't get spelled out, then you're going to be stuck with an issue, and obviously the other party may not want to pay you. And if it's not spelled out in the terms of the contract, you have nothing to rely upon. And in most contracts, there's a clause that basically says that it doesn't matter what the parties said before the written agreement, whatever's in the contract is what prevails, right? So again, you have to be careful, even if you spoke about a circumstance or a situation, if it's not in the contract, it won't matter.
Okay. So an email then doesn't count if that clause is in, so are you saying if the clause is in the email that nothing prior to this contract counts, then that's not going to, phone conversations, emails, not going to count. But if that is not in the contract, then could you use an email as proof that someone agreed to do something?
If the clause is not in the contract, the no superseding clause, then yes. But in most contracts there are, you know, at the very bottom, it's one of the last few things, and people don't really read them because it's like a couple of lines right before you sign. So you're like, okay, I got through the services, I got through the compensation, I'm good. But if you don't make sure that everything that you've spoken about is incorporated fully in the contract and it reads the way that you understand it. You know, if you don't understand it, stop. And that's an issue, because if it doesn't make sense to you, then you need to ask questions and you need to get clarity. And don't assume, because again, just because you spoke about it in the email or the conversation, if it's not written the way that you understand it in the contract, don't sign it until it is the way you understand it.
Okay. You know, so I think everybody after this session is going to jump on the computer and look at all their contracts to make sure it's got that little clause at the bottom.
Yeah, it's a very important clause, you know, and speaking of important clause, several important clauses include the confidentiality clause, right? Yeah. One of the contracts that we talked about last time was an NDA, a non-disclosure, right? It prevents a party from speaking about all of the confidential information that you're going to be sharing during your discussions. So if you don't have that clause then incorporated into your agreements, then again, whatever you've done during the time that you're working together with this party, you may use it later on, or you may divulge it without a confidentiality clause. You can't make the assumption that someone is not going to say something or do something because, you know, it's understood. It's not understood unless there's a clause that says there is confidentiality in everything that is being said and done. You know, obviously everything that's not public information. Yeah. So it's really important to make sure that that confidentiality clause that you may have had with this person at the beginning is included in the contract that you end up signing with them as well.
So are there a key, like a number or of contracts that every company should just kind of have a boilerplate version on hand? You know, could you tell us what those are?
Yes, absolutely. So the first thing every company should have is an NDA agreement, right? So before you even get into a relationship with someone, you're going to have a conversation with them. So before you have that conversation, you should have a non-disclosure agreement. And that includes friends and family. I'm not, excluding them. And I actually want to highlight, especially when you're dealing with friends and family, keep it business. And this way, you know, if you are creating a situation or want to create a relationship, a business relationship with your family members or your friends, in order for them to take you seriously as a business, they're going to have to start seeing that you're treating yourself as a business entity. So don't be shy to include, an NDA when you're dealing with friends and family. And of course, an engagement agreement. So depending on the type of business that you have, having a form of client engagement agreement, customer engagement agreement. So it'll look different for different businesses, but each business should have a personalized template of their business engagement agreement for everyone that's working for them. And that will help, limit a lot of the issues that may come up, because now you already know what you need to deal with. And the only terms you may, adjust in those things are the names of the parties, maybe the types of services that are going to be performed, and then the compensation. But all the other terms will stay in there as long as you've, made sure that those are the things that are relevant to your business. And then the other thing, of course, is either an independent contractor agreement or an employment agreement, or maybe both, depending on, your business, because there's going to be a time where you're obviously going to be working with people, depending on the type of employment relationship that you're going to have with them. It's going to determine whether it's going to be an employment agreement where it's, you're part of the company and you get paid through a W-2 stub, and the company pays your taxes out of that, or you're an independent contractor where you get paid as a 1099, and you're not the company does not pay your taxes, and you'd have to pay your taxes separately. And there's also liability differences, of course, for those two types of employment or independent contractor situations, which we'll get into later. But those are three basic key things that you can utilize and use for your different situations.
Now, how is a service agreement different, or is it the same as like the engagement agreement?
So essentially, the service agreement is your engagement agreement. Okay. It would be the depending on the service that you are offering, the type of engagement that you would be having with your clients. And again, that's one of the most important agreements that you're going to have as your business, is that service agreement. And even if your business is an e-commerce business, well, that service agreement is actually in your website. The terms of service, the terms and conditions, those are your service agreements. That is a service agreement. Okay. So they're still, your customers are still checking when they're passing through, buying the product, they're still agreeing to the terms of your service, of your product, and everything that's backed up behind it. So again, you want to make sure that that's personalized. And I know a lot of people are trying to cut through corners and getting online templates of terms and services and privacy policies. And these things don't come with much assurances, by the way. So, if you get in trouble, whether it's with your customer for something that is not part of your service, but apparently it's in your terms of service, which you didn't really pay attention to, mm-hmm. or in respect to your privacy policy, if you haven't updated it, as we know, with the European Union, there's a GDPR that has to be applied if you're marketing to that to those customers, and also now in the U.S. with the California CCPA. So California has sort of, it's not as extensive as the GDPR, but it's there, and that applies to California residents. So how do you prevent that? You have to make sure that you are up to date with all of your privacy policies, because any penalties can come down, could take you out of business.
Yeah. Well, I'd like to bring in Dee and Catherine, because I know with all of the events that they put on, they probably have dealt with service agreements a lot. Kat, I know you're in the middle of putting on, getting organized for High Tech Moda.
Yeah.
What kind of service agreements are you working with right now?
Well, we just got the hotel secured for High Tech Moda for the Edison. So we're in the process of developing that. And as Sharon said, it's highly specific to the hotel and what they're promising us and what we need. So we're working that out right now, but we go point by point, and then we sit down and we hammer out the details, what we need, what they provide, what they can provide, what they're not going to provide. And then we put a full service agreement, which has their names on it, our names on it, and the parties. And then we both sign it. And that's what you're in but we do that for every single event and every single venue, because they're different. There are different requirements and different things that, but mostly it comes down to liability and accountability. And, we had a problem with National Geographic. And, I went to Sharon and I said, we need help with this, because they claimed that we had done damage to the event space 7 months after the event was over, and they kept our money, kept our deposit, and said that we couldn't get it back because we had done damage and they were going bankrupt. So all we could do is basically get 10 cents on the dollar. And that was that almost really stopped us in our tracks. And, if we weren't able to take that off as a loss, for the producer, it just, and and we had no legs to stand on. I mean, it was just, you're up with bankruptcy. All this pandemic stuff happened, and who would have thought National Geographic, that the Times Square Alliance, would go bankrupt? So at least we had the contract, but it did very little when they went bankrupt, and we lost our deposit, and we were supposed to have a deposit for September. And so we lost that. So these are really tough times.
Yeah. Sharon, is there anything that could have been done differently to protect themselves in that kind of situation? Because I mean, obviously, to come back so far after the event and say that there was damage, how do you protect yourself from something like that happening?
Well, this was definitely another learning experience. And as Catherine said, who would have thought? But, in these times, desperate times calls for desperate measures. And this was a company that was basically reaching and trying to search for money. And, based on the contracts that it had outstanding, and it sort of took the deposits on. But bankruptcy is definitely a different, when you go into the jurisdiction of bankruptcy, there's a whole lot of rules. And, I've done bankruptcy, so I appreciate the rules. And as Catherine said, sometimes your hands are tied. But what we, moving, in hindsight, obviously we could have put a clause in the agreement. I mean, I wasn't there to do the agreement. I just helped with the resolution, but we could have, put a clause in the agreement that they had 30 days to make a notice, right? So they could have had only a certain amount of time to put the notice in of the damages or whatever they were allegedly claiming. And if not, then they waived that right. And of course, there was also a no return, on the deposit.
No refund. Yeah.
No refund on the deposit as well. So that's something, of course, from the pandemic, I've learned with a lot of events that are now, questioning those contracts that have a no refund policy. As we saw, the wedding industry was completely shattered this past year, and a lot of people lost their deposits because they're notorious for no refunds. And so now people are getting smarter, and they're, not wanting to take chances. And I think as consumers, we also, have a role to play in how companies end up, creating these contracts. And before, obviously, we were powerless to it. But I think now, if everyone says, I'm not going to sign a contract that says no refund, guess what? The company's going to be out of business. So there should be some reasonable clauses put into these contracts that do allow the parties a fair way to, get the refund back if it's situations like we had, where you cannot control that. This is not, the bride fled or something like that. This is a pandemic where, legally speaking, no one could hold events. And yet these event spaces were still holding the deposits, unfortunately. So I think now we've learned even more than before. And in your contracts, have time limits to which someone can claim damages, right? To hold a refund. And the same goes with real estate. There's a certain time period, when you leave a lease, for example, that the landlord has to hold your deposit, right? So same thing needs to happen in the event world as well. But with respect to bankruptcy, that's something that, again, and I've dealt with a lot of big businesses that have gone under. I represented Sony at one point that dealt with this issue, and who would have thought, right? But it happens. And once you're in the bankruptcy court, there's really nothing you can do. It's completely out of your control. So there are certain things that you could do in the contract to prevent that, but not everything can be prevented.
Yeah. And I think that's what's so hard about a contract is you go into it with all this enthusiasm that, oh, I'm so excited about XYZ, and you don't think about what could go wrong. And that's why it is really good to have an attorney go over, especially something that where there's so much money at stake, because they can think about what can go wrong. Dee, I know you've used a lot of service agreements as well. Tell us about some of the different kinds of service agreements that you use in your business.
Well, I implement NDAs always, but then I also implement media partnerships. I implement sponsorship partnerships, designer agreements. You know, you have to cover everything just because even volunteers, I've always done this. Like I have them sign something. The reason I do that is because there was a time where I had a volunteer and she very enthusiastic, very smart. She came to my event and she after the event she started using the pictures. Now it's one thing to say, hey Dee, I love to add these to my portfolio, you know, that's different. But what she did was very deceitful. She took the pictures and she added it and created a PR company.
Yeah.
So yeah, crazy chick. So anyway,
Ballsy.
yeah, she's ballsy, but you're crazy. I'll show you crazy.
I actually know someone.
I'm crazy.
I actually know like an established PR company or fashion show company that used pictures to promote their fashion show. They used pictures from somebody else's fashion show.
Oh, okay.
And, I mean, it wasn't stock.
Stock photography. So the thing is that she created a PR company. She used all my photos for that event that she volunteered and made it look like, hey, we produce shows, we do this, we do that. So I get alerts. And so the alerts that I got, I saw, wait a minute, what is this? So I called her. She acted, you know, obviously like she didn't know, blah, 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 you know, typical sociopath. So what I did was I called the lawyer and I sent her a cease and desist. And then I said, you know, you have 24 hours to take this down, to remove all photos. And she did.
Good. So that's good. So you didn't just take it on the chin.
Right. But the thing is, if I wouldn't have had that volunteer agreement, or if I wouldn't have had those agreements in place, it would have taken a little longer to prove. Do you know what I mean? But because her name was on it, her signature.
Right. She agreed to it. Right.
She agreed. There was an NDA clause in that volunteer agreement. There was a whole bunch of things in place. So if I didn't have that, it would have been harder. And so, you know, again, even before that, I've shared this in other panels, like I had to learn the hard way about trademarks and, you know, important things to protect your assets, because if not, it's unfortunate. Like people do, I don't know what it is.
Well, you know, another
back on people's lack of integrity.
Well, another area that I think people have to really think about too is their email lists. You know, you go.
Yeah, like me and Melissa had a situation recently. We're not going to mention names, but you know, I trust Melissa. Melissa, I hope you trust me.
Yes.
We have NDAs in place. You know, her and I have NDAs in place. We have agreements. And we were working on a project on a billboard, and this person outside of us shared our list with the people that we were like, what the WTF? So, you know, I went on damage control. I called my contact. I called Melissa. Everything was resolved. But, you know, things like that happen because there are people that don't like to follow protocol, that don't have integrity and don't, you know, they just want it's all about them.
Yeah. And things like email lists of like say you've had an event and you've got all these people that bought tickets and you've got this email list. That's so easy for someone who's involved in your event. Maybe you're partnering, or maybe it's just an intern. It's so easy for that to be copied and taken. So that would be the kind of thing. Would you include that in an NDA?
I have that in the agreement. Like you can't share, even like in my email, there's a clause says you can't transfer, copy assets, copy, like, you know, I try to cover all my tracks. Obviously, there's always going to be those people that they don't give a crap. They're like, well, you know, sue me, whatever. But you have to put those in place. And yeah, and you know, I think the business people out there, like when you're doing business, like I think integrity goes a long way. And this is a very small industry and word gets around. So
Yeah.
when you don't follow protocol, business etiquette, and have integrity, and just, you know, like anything that anybody contacts me, like somebody contact me from Melissa's contacts, I will always let Melissa know and say, hey, Melissa, this person contacted me. I would never like go behind and go, hey, like I won't do that because I have a long-standing relationship with Melissa. And you know, I just wouldn't do that. And so I think people need to, I think before you start taking these trademark, copyright agreement, take an integrity class.
Yeah. Sharon, that I often see that clause in the bottom of an email about confidentiality. Does that, if you are sending important documents about business plans and different like things like that through an email, will that clause protect you?
It depends on how, you know, the intent of the parties and what is being exchanged. Of course, there's a confidentiality to the extent that, you know, usually that applies when you're dealing with, say you send somebody an error, right? You send somebody documents or information in error. Well, at least with that, you know, you can hold them accountable for not disclosing it because they're not a privy to it. Of course, you know, as to Dee's point, that all goes back to integrity, and whether someone is willing to uphold the rules of law. But yeah, it as I mentioned and Dee illustrated beautifully, you want to start off your relationship with an NDA. So everything is clearly documented and it has to be specific. Don't just send a general NDA. It has to be specific to what you're going to be talking about so you can trace that information to the extent that it ends up getting disseminated. And then follow it to a confidentiality clause that gets incorporated into whatever it is that you are doing. So with Dee's example, if it's a volunteer, so you're not actually getting work, right? It's a volunteer. You absolutely need to have a volunteer agreement because, you know, say for example, they're doing an event, right? Well, it's not just important to make sure that you protect all of your intellectual property and everything that you're doing at the event. And confidentiality does include the email list. That does include all of your customers, your vendors, your suppliers. Everyone that you're working with is part of that because that's how you create your brand. So it does speak to that. But again, it needs to speak to it in the contract. You can't just say everything we speak about is confidential. You have to sort of give an example of what it is that you're going to be speaking about. But then you also, I want to get to this point because I know that Dee and Catherine deal with a lot of events. Release of liability is really important in events. And when you're running an event, even if you have a volunteer, actually, more importantly, when you have a volunteer, you want to make sure that they release that you are released from any liability for their participation in that event. And that would also include your employees that are working at the event, as well as independent contractors. So everyone needs to have a release of liability. And essentially what that does is, you know, there's two main reasons. One is to memorialize the fact that you are warned of possible risks, right? And and that person will be waiving their right to sue you if something should happen at the event. And of course, removing your responsibility for injuries that may arise from ordinary negligence. Now, if you did something at the event to cause someone injury, you obviously can't waive that. So it's, you know, it has to do with ordinary things that, you know, could happen, right? Somebody, let's just think about the fashion shows, right? There's cords running all around all over the place. If someone trips on the cord and falls, right, and hurts themselves, you want to make sure that they don't come back to you and sue you for damages.
What about what about a fashion show, like with the models? Catherine and Dee, do you guys have the models and release?
Yeah, we have a model release, and we're you know, exonerated or whatever the word is from liability. because they
and
can't
crazy
fall
thing,
down the stairs, and they have these extreme shoes, and they twist their ankle, they fall down the stair, whatever. Thank God. I mean, it hasn't happened yet. Knock wood.
how Sharon, how does that work? Because I guess when you guys do events, you do have some kind of event insurance, right?
You have to have
Yeah,
a certificate
You're
of
required to have
insurance.
that.
definitely.
So if a model were to fall on the runway in the shoes and,
Down
obviously
the stairs.
has medical bills that need covered, does the event insurance take care of that?
It depends. Like when you get event insurance, and I always look at I always look at the contract when I do event insurance. It does cover some liability, but you have to be very specific when you put that in there, because there's $1 million insurance. What does that cover?
Yeah.
It covers the venue, it covers you. Like you have to put the names of everything, because if that name is not in there, then that's an issue, right? So you have to make sure all that is in place. And then with models, I just want to say one thing. You also have to always work with the agency that you're working with, and whatever models there are, sometimes they eat food, they have drinks, that in itself is an issue, because sometimes models have allergies or food allergy. I mean, there's a whole ball of wax with that. And so what I always do is I always have somebody check in, like, is anybody allergic to anything? Or I order something that has ingredients, because I never want to get sued for anaphylactic shock or some craziness.
Yeah. So Sharon, what kind of situations would you need a release of liability? Obviously an event. Is there any other types of situations?
Well, let's just say, you run an activity, a wellness center event, right? So you're inviting people to a wellness center. There's going to be, things done during this activity. So you want to make sure you can't, it's sort of like, you've seen at the gym, right? It would be the same sort of rules would apply, where before somebody comes to your establishment to use, to partake in the retreat, or even I've even done them in photography sessions, depending on where they are. If they're on location, especially, I work with a production company and we do releases for shoots that are on location, for even all of the workers that are going to be coming. Because one thing I want to emphasize is, you can't make an employee waive liability for something that's part of their job to do. But going to a shoot, you have to make it a voluntary thing. So you can't force someone to travel to go to a shoot. If it's outside of their of like your office studio, for example. So in that circumstance, you can sign, you can ask them to sign a waiver, and if they don't sign a waiver, they don't have to go, and you shouldn't make them go, because you are taking now responsibility. As I mentioned, I'll just take this for example with the production company, and they do shoots, they do commercials, they do print, everything. So and they do it on location a lot of times. Well, everyone that travels has to sign from the moment they leave, during this, what can happen on a plane, what can happen on a train, what can happen on a bus, what can happen in location, what can happen in Hawaii, for example, right? There's volcanoes, there's all sorts of things. You have to spell it out. And this is the key to liability releases, because some people are saying that they don't, they're only as good as the paper that they're written in. Well, that's not necessarily true. That's the fact if only you're using boilerplate and it doesn't describe what your situation is and what you're releasing your liability from. So you have to be as specific as possible with the release and what the activity is going to be. And if they don't sign it, then they don't go. And you can't say that if you didn't sign it, you're still going to be under that covered umbrella. And to Dee's point with insurance, a lot of times the insurance doesn't cover this because they're assuming that you're getting waivers for all of this additional stuff. Of course, you can't get a waiver from a customer a lot of times, right? So if you have an event and a customer comes and, you know, gets injured or whatnot, like for example, in a fashion show, you know,
or at our Fashion Week networking party where the ceiling something fell from the ceiling and hit one of our party guests right in the head.
Sneha's friend.
Yes, it was very scary. And it really was painful. Right. And luckily the hotel, I mean, obviously they had insurance and it was just some freak situation. But they did handle it well. And they were like, you know, as far as I know anyway, no one ever came back to me and say they did it, but you know, that could have been bad. That could have been a death, you know.
Yeah,
that would have been my last party.
Yeah, that's scary. But there you go. You know, throwing a party, that something could happen. So that's why you cover yourself, and to the extent you work with an event that has insurance, so that if something happens at the event, they are, you know, going to step in and cover it. And that brings me to a term that comes up in these situations, and it's called indemnification. And that is when one party agrees to hold the other party harmless. And in a situation like this, if you had with your agreement with the hotel, for example, if you had an indemnification clause that was mutual, so let's take your scenario when it says that the hotel will hold you harmless if someone comes and sues you for their negligence, and vice versa, the hotel would come and sue you. I mean, you would hold the hotel harmless if something you caused injury to someone at the hotel, for example.
I'm having such an anxiety attack. We've had 5 of those events and we've never had a contract like that with the hotel.
Well, you're going to now.
Oh my God.
Wow. You know, you definitely got lucky, but that's why you have that in the contract. And so I've had situations where a small business gets themselves involved in a lawsuit with a bigger company that they were working with. And, you know, when there's a lawsuit, usually people just sue everybody and, you know, let them figure it out. So if that let's just say that person that was injured ends up suing Fashion Mingle because it was your event that they held, and they didn't end up suing the hotel, or even if they did sue the hotel, if you have an indemnification agreement with the hotel, because it was actually their damage, right? It was their fault. Mm-hmm. You can turn around and say, okay, you're paying my attorney's fees for being involved in this.
Oh, wow.
And you're going to pay whatever damages come out of this because it has nothing to do with me. But guess what, Melissa? If you don't have that agreement and you get yourself involved, you have no one else to turn to.
Wow. That's really scary. I feel really, really blessed to have had this conversation now. Now I know what happens next time. Well, so we've only got 10 more minutes. So if you have a question about contracts you want Sharon to answer, please put it in the chat. Let's talk about independent contractors and employee agreements. And then the 5th point we were going to talk about was entering partnerships or joint venture agreements. But why don't we save that till the last Friday, the 4th Friday in April, and maybe also bring in a broader discussion about collaborations, but also partnerships and investors, stuff like that. I'll get with you about the different things that would be a good conversation for that. But so independent contractor and employment. So you had mentioned at the beginning the difference between an independent contractor, you know, you give them a 1099, an employee, you're giving them a W-4. But there's also really strict rules about what you can require from an independent contractor versus an employee. Could you explain that?
Yes, absolutely. I mean, right now, actually, it is a very hot topic in the legal world, and what can happen. You know, there's some bills before legislation, and California just passed this
the
past
Uber.
year. So yes. And this is going to have a huge impact on the gig workers and anyone who wants to stay as an independent contractor, because as we mentioned before, there's great benefits of working for yourself and not, you know, being employed. You can make a lot of deductions and, you know, deal with your own taxes, and have freedom, you know, and flexibility in your work. But the legislation that is looking to change that is basically, you know, it's called the ABC test. And it's a test that employers, like anyone that's hiring a worker, must pass to classify a worker as an independent contractor under the Department of Labor. So, and it's the employers, those that are hiring, that are going to be responsible for the correct categorization. And if they don't, they're going to be facing costly fines. So, and the designation is important because one, it obviously it affects, you know, payment of Social Security, workers' compensation benefits, all these other things that we, you know, that you get the benefits of when you're working under employment, right? Health benefits, you know, workers' compensation. If you do get injured on the job, then you get paid for that. But depending on the work, where the state where the work is being performed, this ABC test may also apply to wage and work hour laws as well. So basically, you know, the ABC test is now being applied in California, but generally the law that it is right now, you know, for most states, it's the common law test, and that consists of 3 parts. And this is what the IRS looks for when they're assessing whether or not you've categorized someone as a worker or an employee. So an employee is a worker is considered an independent contractor if they meet these 3 criteria. So the worker is free from control and direction of the hiring entity. And so obviously you cannot have control over this person's time. You can say, I need this work done. You can't expect hours. You can't expect days. You can only provide deadlines, right? Time limits, but you cannot manage this person's schedule, daily schedule. And you have to be very careful in how you craft this contract. Wow. So that it doesn't look like you're controlling this person's schedule and expecting these things to be done in a very short period of time. And of course, the other thing is the work performed is outside the usual course of the hiring entity's business. This is where people get in trouble. So, for example, if you are hiring, if you are a makeup studio, okay, and you are hiring a makeup director, that person is a part of the business, right? As a makeup studio, a makeup director is a crucial part of the business. It is one of the, you know, one of the main facts of having a studio. So you can't hire a director for your business that is an independent contractor, because that is your business. So anyone that works to the core of your business cannot be designated as an independent contractor. So let me take the example of the production company. They produce things, right? So what do they need? They need lights, camera, action. Those that provide videography, photography, those could be considered employees because they are a necessary part of the production business. On the other hand, if you hire someone to do your admin work, let's just say, you know, just like a temp person that comes in and assists you, or someone that comes in to paint the walls, you know, and redecorate the studio, for example, things like that. Those are not part of your core business. And for those, you could, you know, categorize them as independent contractors because they don't go to the core of your business. And that was the issue with, you know, the Uber and the Lyfts, right? Because Uber is a driving service. So everyone they hired was a contractor, and that's their business, is driving people. So, but in that case, in California, they did win it, but I don't think that's going to hold for very long. But that's the issue, and that's what it's going to come down to. And this second prong is what's going to give a lot of people trouble, because for the most part, a lot of small businesses have been hiring people that do all sorts of work for them as independent contractors, not wanting to pay, workers' comp and all, Social Security and all the taxes for these. And it's a payroll nightmare unless you have, some payroll structured up. But now we're seeing that and this is coming to New York as well. So it was on the books to be passed last year, but of course the pandemic hit and everything got halted. But this is looking to come. The ABC test is looking to come to New York, and it's already in California, and it's definitely causing a lot of issues for companies that are doing business in states that require these very stringent rules with independent contractors. And
when is that coming, Sharon? When is it coming to New York or New Jersey?
Well, I mean, we don't know, because obviously it's on the books, and there's been so much more important things to deal with in our legislature. So it may be by the end of this year, depending on if they get to everything that's on the bills. It may be, but there's opposition. There's opposition, of course, from people that are gig workers that don't want to be designated. So this brings me to my last point, right? The worker is customarily engaged in an independent, established trade, occupation, or business. Makeup artists, photographers, people that generally are working for themselves. Yeah. So that's okay if you're traditionally, so for example, but a secretary, those are not people that generally work for themselves. So again, that's going to give you a problem if you try to hire a secretary as an independent contractor, and that's not necessarily what a secretary does. Although the rules are changing now, we have virtual assistants, and they're all working from home, and they're working for each other. So I feel like, I don't know if this is going to pass, honestly, with the changes that have happened in the gig economy after the pandemic and after all these things, because it's not, the purpose of the bill was to protect gig workers, of course. It's to protect those that are, working for a company, that they don't have protection if they get injured, if something happens to them. But I think on the wider scale, people are losing a lot of benefits from being an independent contractor by, obviously doing their own taxes, being able to do a lot more deductions than you would if you were just being paid as a salaried employee. And, being able to cover that with your own insurance, right? Getting a short-term liability insurance or something for yourself to cover you in your business. So I don't know if it's necessarily going to pass, because there is a lot of people that are not happy with it. And if you're one of those people that are not happy with having to be employed as opposed to doing, being an independent contractor, then contact your governor and make sure that they don't pass this bill.
Yeah. What about something like a designer has a seamstress and a pattern maker? And maybe they do have enough inventory that the people are constantly busy. Do those people have to be employees?
If you're a designer, then a pattern maker, a seamstress, those are all key roles in your business, and that goes back to the second criteria. If they are key, if the people that are doing the work are key roles in your business, then it's hard. Then they have to be categorized as employees. And, unless you craft it very carefully and very creatively to make them sound like they're doing other things that are outside the ordinary course of your business. And it just so happens that they do some of this seamstress work too, but they're doing other things. So you've got, I think what's happening is you've got to be very creative. So again, I just want to caution everyone that is trying to use boilerplates for their contracts, because that will 100% get you in trouble with this law. And if it doesn't catch up with you now, it could catch up with you later, because the IRS has the right to go back and audit and, you know, confirm whether or not your employees, and I've actually worked at a firm a few years ago, and we had employees that were coming in and out, you know, past the student phase, sort of like an internship, and they were independents. And the firm got hit. And it just sort of got that letter out of nowhere that said, hey, these people perform essential work for your business. They have to be employees, not independent contractors. Okay. So it can happen to anyone and everyone. And that's the point, is you want to make sure, even if you write in the contract that this is an independent contractor agreement, it's not always up to you. It's also up to the law. And if you aren't following the laws in your state, then you could still, you know, get in trouble.
Sounds good. Okay, well, let's wrap this up with a final question from Dee.
Really quick. Shereen, what about if you use a virtual assistant that doesn't live in the U.S. and you pay them whatever the minimum wage is over there?
That's a really good question. That's something that's coming up a lot. I mean, obviously, if the person does not live in the United States, then the laws can't protect that person. So that will help you avoid, you know, some of these taxation laws if they are performing work that would be considered essential to your business. So I wouldn't, you know, that's the part of the IRS. They're protecting the workers. So if the workers are not in the US, then there's, you know, you can't pay for workers. They don't have a social, they don't have any way of supporting them. So that, because that money is supposed to go towards their benefits, right? And so, yeah, if you're working with virtual assistants or people outside of the country, then you wouldn't have anything. You shouldn't be concerned about this law.
Okay, awesome. Well, this has been a wealth of information. Thank you so much. As usual, Shereen, you always clarify so many complicated issues.
No, you're good.
Yeah. If anybody,
head's spinning.
Right. If anybody has any questions for Shereen, you can send a chat to her over Fashion Mingle. And then also Kat and Dee are both planning fashion shows for the fall. If anyone is interested in appearing, I know Kat's got High Tech Moda. What's the dates of that, Kat?
10th and 11th.
Of September?
Yep.
Okay. Oops. So we just
at the Edison.
We just lost Dee, but I think Dee's doing Times Square Fashion Week around the same dates. And then Hamptons Fashion Week is going to be in August. So if anybody needs to reach out, you can also catch them over the Fashion Mingle chat system as well. Okay, well, thank you, everybody. Have a great weekend. And good luck to your little girl, Shereen. I hope she feels better.
Thank you so much. Thanks, everyone. Have a great weekend.
Bye.
Bye. Bye, everyone.